Introduction to International Law. Branches of international law, examples. The law of sea. History of international law. The early origins of international law as we know it now can be found in the informal rules and common practices countries abided by when they were engaging in cross-country trade in the late Middle Ages, somewhere between the 15th and 16th century. These traditions, rules, practices, and ways of doing things were necessary to ensure predictability in international relations. At the very start, these rules were mostly based on religious considerations enforced by the Catholic Church. Introduction. The subject of the law of the sea has been a central concern of international lawyers since at least the time when European adventurers set out to discover and conquer the New World, if not before. In an age devoid of aviation and naval power, the domination of the high seas represented the best guarantee of both regular trade and secure defense. For those states, such as Great Britain, dependent on the import of food and raw materials, control of maritime routes could not be a matter of indifference. By the end of the 20th century, a considerable part of international law pertaining to the law of the sea was contained in the United Nations Convention on the Law of the Sea, 1982. However, to understand the nature of this multilateral law-making treaty, it is necessary to say something of the history. By 1400, if not before, rulers had come to recognize that certain distinctions could be made. Common sense dictated a distinction between internal waters, ports, harbors, roadsteads enclosed in bays, and all other waters. At the end of the 15th century, European states began to assert rights over the oceans. Prior to that date, the high seas had been regarded as free for all to sail and fish. Pope Alexander VI, in a series of papal bulls, attempted to apportion territory in the oceans between Portugal and Spain. In the papal bull Intercedere, 1492, he drew an imaginary boundary line from north to south 100 miles west of the Azores and the Cape Verde Islands, and ruled that the oceans and territory beyond were subject to Spanish sovereignty. This was not acceptable to Portugal, who began direct negotiations with Spain that resulted in the Treaty of Tordesillas, 1493, under which the Portuguese claimed the route to India as well as part of the South Atlantic, while Spain asserted rights over the Pacific and the Gulf of Mexico. The extent to which the rules were uncertain is illustrated by the fact that the Portuguese were obliged to ask later popes to confirm the territorial arrangement made in the treaty. So that, in the early 19th century, any international law of the sea was based on customary rules, and those rules recognized the concept of the high seas over which no state could claim jurisdiction, and also a maritime belt of territorial waters whose breadth was sometimes said to be 3 nautical miles. That position would remain unchanged into the 20th century. One of the reasons was that colonization meant that much of the world's oceans were indirectly subject to colonial powers. In the 20th century, decolonization would increase the number of independent coastal states who would seek to achieve a greater measure of control over adjacent waters. It was recognized after the First World War that it was not sensible to found the law of the sea on customary law alone. In 1924, the League of Nations requested its committee of experts to draw up a list of subjects suitable for codification. Included among the list was the topic of territorial waters. The committee began consultations with interested governments, and sufficient progress was made to warrant holding a conference at The Hague in 1930. However, this conference was only a limited success as no international convention emerged. Nevertheless, a series of draft articles on the subject of territorial waters were produced. Although no further substantive progress was to be made in that decade, interest in the subject of the law of the sea grew as individuals speculated on the possibility of sustained deep-sea drilling and exploration. The establishment of the United Nations in 1945 led to the creation of the International Law Commission in 1947, and this body has, since that date, been active in seeking codification of the law of the sea. However, the main impetus for action derived from action taken by the United States in the form of the Truman Declaration issued in September 1945. In that statement, President Truman asserted, "Having concern for the urgency of conserving and prudently utilizing its natural resources, the government of the United States regards the natural resources of the subsoil and seabed of the continental shelf beneath the high seas but contiguous to the coasts of the United States as appertaining to the United States, subject to its jurisdiction and control. In essence, the Truman Proclamation comprised two statements, one in respect of the natural resources of the subsoil and seabed of the continental shelf and the other with respect to coastal fisheries in certain areas of the high seas. The danger of such unilateral lawmaking was not only that it broke with the traditional maritime zones recognized by customary international law but that it prompted others to act. In the years between 1945 and 1955, many Latin American states unilaterally declared maritime zones of varying breadths. The Latin American states unilaterally declared maritime zones in respect of coastal waters and subsoil to a distance of 200 nautical miles. In the same period, the Anglo-Norwegian fisheries case indicated that there were considerable differences of opinion about the meaning of even long-established customary rules, in particular in respect of the drawing of baselines. The developments prompted by the Truman Declaration, if left unchecked, would have meant that there was no uniform law of the sea. Thus, the International Law Commission began work on the subject in the early 1950s and by 1956 had consulted sufficient states and produced a detailed enough report to warrant the calling of an international conference. The first United Nations Conference on the Law of the Sea, UNCLOS-I, was attended by 86 states, nearly double the number participating in the 1930 conference. The conference produced 4 conventions: the Convention on the Territorial Sea and the Contiguous Zone, the Convention on the High Seas, the Convention on the Continental Shelf, the Convention on Fishing and Conservation of the Living Resources of the High Seas. The first 3 of these conventions were based on existing rules of customary international law as analyzed in the documentation of the International Law Commission. Not surprisingly, these 3 conventions attracted a high number of ratifications. The 4th convention went somewhat beyond the existing customary law and attracted only a limited number of ratifications. Thus, the state of the law of the sea can be summarized as follows. All states are governed by the relevant rules of customary international law, which in many cases have been repeated in the provisions of the Law of the Sea Convention, 1982. Secondly, the Law of the Sea Convention has had the effect of creating new rules of customary international law. Thirdly, those states that have ratified the Law of the Sea Convention, 1982, are bound by its terms. However, as some states have not adhered to the 1982 convention, such states may be bound by the terms of the 1958 conventions. One of the objectives of the Law of the Sea Convention, 1982, was that it should be comprehensive and universal, and the position can be contrasted with the law on human rights, where there has been tendency for the law to develop on a regional basis. Internal water. Internal waters are those waters not part of any maritime zone nor part of the high seas. More specifically, they are defined in Art 5, 1, of the 1958 Convention on the Territorial Sea and the Contiguous Zone, where it is stated that waters on the landward side of the baseline of the territorial sea form part of the internal waters of the state. This definition is for the most part repeated in Art 8, 1, of the 1982 Convention on the Law of the Sea. The waters form part of the territory of the coastal state and are distinguishable from the territorial sea because of the absence of any right of innocent passage. The sovereignty of the coastal state over internal waters is expressly stated in both international conventions. Thus, it is accepted that a state may exercise jurisdiction over acts taking place on vessels within its internal waters 24, even though the flag state of the vessel may exercise a concurrent jurisdiction. In general, the coastal state will not interfere with the exercise of disciplinary powers by a captain over his crew. Baselines. The concept of the baseline is of supreme importance in the law of the sea because it constitutes the point from which the breadth of any particular maritime zone is calculated. At customary international law, the baseline was formed by the low water mark around the coast of a state. This principle was reflected in Art 3 of the Geneva Convention on the Territorial Sea and Contiguous Zone, 1958, which reads, "Except where otherwise provided, the normal baseline for measuring the breadth of the territorial sea is the low water line along the coast as marked on large-scale charts officially recognized by the coastal state." This wording is repeated in Art 5 of the Law of the Sea Convention, 1982, and the text of the article appears under the heading Normal Baseline. In many cases such an approach will be acceptable, however some coasts are not straight and are subject to indentation. It is therefore necessary to formulate rules that can provide for different geographical conditions. Such rules need to be precise to prevent states engaging in generous interpretation. Where the baseline is drawn will determine the extent of internal waters, and states may be tempted to increase the breadth of such waters for defense purposes. The method of drawing baselines in abnormal geographical circumstances was considered in detail in the Anglo-Norwegian fisheries case. In that case, a Norwegian enactment of 1935 had set a baseline along almost 1,000 miles of coastline. The decree had been foreshadowed in earlier decrees of 1869 and 1889. The Norwegian coast comprises fjords, rocks, reefs and islands, some of which run parallel to actual coast, and this part is known as the Skjerd, a Norwegian word meaning a rock rampart. Rather than drawing the line by reference to the appropriate low water mark of each island and rock, the Norwegians had, since the 19th century, drawn a straight baseline linking the outermost points of the Skjerd. Such a method had the effect of widening the area covered within internal waters and the territorial sea, thus reducing the area that would otherwise be high seas. However, such a method, unlike the conventional method, did allow the Norwegian territorial sea to be determined with reasonable precision. From the late 1930s, disputes arose with Great Britain as to fishing rights in these waters. In 1949, the United Kingdom brought a case before the International Court of Justice arguing that Norwegian method of drawing baselines was contrary to international law. Islands. In respect of islands, the normal principles set out above apply. An island is defined by Art 121, 1, of the 1982 Convention as a naturally formed area of land, surrounded by water, which is above water at high tide, and such an island will have a maritime belt. The definition makes it clear that where land is above the sea at low tide but below at high tide, then it will not be an island, but it may be employed as base point under the straight baseline system if lighthouses or similar installations have been built. In this context, it should be noted that Art 121, 3, of the 1982 Convention provides that rocks which cannot sustain human habitation or economic life shall have no exclusive economic zone or continental shelf of their own. The precise wording here stresses capacity to sustain human habitation rather than actual habitation. Cases of uninhabitable rocks have given rise to difficulty, and there is reason to believe that Art 121, 3, does not restate a rule of customary international law. Archipelagic states. One of the problems that had been left open in the 1958 Geneva Conventions had been the question of the drawing baselines around archipelagos. There is a natural tendency for an archipelagic state to draw straight baselines around the entire island territory, thus enclosing the whole territory. Concern, however, had arisen prior to 1958 when Indonesia and the Philippines had indicated in 1955 and 1957 respectively that they would enclose their entire territory within straight baselines. Domestic legislation had followed in 1960 and 1961 respectively. After 1958, many archipelagic states in the Indian and Pacific Ocean had become independent, so there was a need to produce an agreed scheme. Prior to 1973, many maritime states had opposed any special regime for archipelagic states, fearing that such a regime would lead to the expansion of the territorial sea and limitations on rights of shipping. However, archipelagic states advanced their case with considerable force during UNCLOS 3, and special provision was made in the 1982 Convention. For the provisions to apply, there must be an archipelagic state, and this is defined in Art 46 as follows. Archipelagic state means a state constituted wholly by one or more archipelagos and may include other islands. Archipelago means a group of islands, including parts of islands, interconnecting waters, and other natural features which are so closely interrelated that such islands, waters and other natural features form an intrinsic geographical, economic, and political entity, or which historically has been regarded as such.